trade in living animals, and partners manage business with distinction. Approximately 50% of foreign trade pollen and rubber have been harmed as a result of trade. Internationally, billions of dollars are earned illegally, and here, most species have become destroyed. The foreign trade has endangered many species and continues to use to skip animals, including the Asian golden cat. The Asian golden cat, particularly mentioned in this situation, is an animal listed on site as a hammer swan and is listed by IUCN as near threatened. According to paragraph 1, Article 2.5, the Asian golden cat, a hammer swan should include
for just a second. I understand that Asian golden cat is endangered, but why does that matter to your business? Why are you bringing that up? It seems like a policy matter for the state to deal with. So how is this coming up in an arbitration?
Thank you for your question. The arbitrators, because the arbitrators are serving the purpose as reality represents, many consumers today appear to use real fur from animals in general, especially in endangered animals, because it harms the ecological systems, because they don't want to be inhumane. And in some cases, high-quality fur has a higher price than the real one. So Tencent is liberating the consumer's trust in using real fur. And in this situation, Tencent adapting trade commercial is illegal, opposed to the cross-adoption side, which makes economic losses to HCMULAW. The arbitrators, for the Commission, I will continue our submission. Appendix 1 shall include all species which are highly threatened, which are of major factors by trade. Trade in these species must be subject to particularly strict regulations and must be only authorized in special circumstances. In 2007, the IUCN Red List classified the Asian golden cat as vulnerable, and just 1 year later, the level was up to near threatened in 2008 due to hunting hazard and habitat loss, which demonstrates.
I see. Yes, today. So it's listed under science. Like that's clear. So let me just drill down here further. The issue with the respondents selling this fur to you, how does that harm your business? Why? How do you have a claim based on that?
Because the arbitrators, according to paragraph 1, article 2.5, trade is business listed on appendix 1 must be authorized only in exceptional circumstances. Why HCMULAW, always pursuant to law, Tencent is conducting commercial trade, which is illegal, which is breaking out
May I interrupt? Okay, can you just request to specific questions to the arbitrators that how could that harm you, harm your business, in order for you to lay on the claim against in this
how does it relate to your claim? How does it relate to your damage?
Because the arbitrators, thank you for your question. Because the arbitrators, HCMULAW never failed to label rightly, correctly, is a garment, is for a garment. And Tencent in this situation, this label of their garment just targets potential financial gain, which constitutes consumers' growth in competition and fair competition, and which constitutes misleading customers. And then they just want our customers. They just make economic harm, make economic losses to our enterprise.
Okay.
And they have responsibilities now that the government, the well-being of their enterprise is made from endangered species, which disrupts the ecological systems of the animals in general.
All right, we understand that. But how could you prove that you suffer economic loss?
Because the arbitrators, many people believe that the fur garments made from Tencent is made from high quality fur, and high quality fur in some cases it is more
stick with your loss. Do you have anything?
Well, I still don't see the connection with how this is, how this would affect your customer decision to come to you and buy it.
Because the arbitrators, because the arbitrators just more articulating the trust in consumers in using poker. So the consumers, the government which Chessmore is selling is poker, and they lost all their trust in poker because they have a lot of misbeliefs that our government and our poker is just a real firm. So it makes a lot of difference to our enterprise. But a contrary of people, a contrary is absolutely different.
That's okay. But wouldn't the customers actually be happy to get real fur as opposed to faux fur? Faux fur is an imitation of real fur. So wouldn't the customers, if their expectations are not met, they actually exceed their expectations. If they get faux fur, then they get real fur. So how does that harm Jack's Law?
Because the arbitrators, they don't like real fur anymore. They just like poker. They just like to hold their belief that against the animal rights. Because the animals are entitled to the possessions of the lead. That's the most interest. They know that. They want to protect the animals, so that they're just in favor of poker, not real fur anymore.
Okay, you know that the time is up, so do you want to sum up your argument?
Yes, the arbitrators, can you permit? Please, I'll be honored if you give me 2 more to represent. The arbitrators, following Singapore's adoption of SARS, told that this requires preference and representation of import permit certificate when never importing goods into Singapore. So told that has responsibility in knowing every information related to these commodities, in taking and due care in commodities. The arbitrators, the seller has responsibility in investigating the origin of the product, because the full origin is unknown to consumers in this situation. So it's the purpose of transaction. So it's unfairness. Something is supposed to disclose that the government commits on 4 endangered species, namely Asian and cats, and we have to emphasize that again.
May I interrupt you? What do you think about the fair trade practice?
The arbitrators, and fair practice is that you disrupt the customers, or you do something that's unfair in the market that attracts the customers, comes to you, visit you, but if you know the truth, they won't come to you more. So I think the unfair competition is that whenever you do something that it is not equitable, that it is not reasonable, so that the others can compete with you in a healthy environment. The arbitrators, our definition is that the arbitration tribunal has authority to award a penalty for a student sales misleading. The scope of arbitral authority confirms may be broad or limited, depending on the specific wording of the arbitration provision. And in this situation, the Colombo Regional Center for Arbitration Moot is the governing law, and however, as we see, Singapore Arbitration Act adjusts the same matter with Colombo Regional Center for Arbitration rules in all issues covered, and according to Article 3 of the Singapore Arbitration Act, these acts shall apply to any arbitration where the arbitration is in Singapore, and where part 2 of International Arbitration Act does not apply to that arbitration. And Thompson and Chessmore replied, in this situation, strongly articulated the agreement that all hearings and proceedings will be held in Singapore as an arbitration. So Singapore Arbitration Act in this situation is the applicable law. And the arbitrators The arbitral tribunal may rule on its own jurisdiction, including a plea and impersonal jurisdiction, and any objection to the existence or validity of the arbitration agreement at any stage of the arbitral proceedings, according to Article 21, Singapore Arbitration Act. Besides, use the term of the law on international commercial arbitration, which adopted by the Kuala Lumpur Regional Center for Arbitration, stipulates similarly at paragraph 1, article 16. So, in conclusion, referring from this regulation, it's undeniable that the arbitral tribunal has authority to award a penalty for future sales of Mr. Moot's goods. Thank you for your listening to arbitrators. And next, our co-agent will represent our next submission.
Good morning, arbitrators. My name is Lee. In the next 7 minutes, I will be addressing 3 submissions. First, concerns unfair business practices should be stopped by an injunctive relief. Second, Singapore Court has the authority in granting an injunction and would enforce such an order issued by a private arbitral tribunal. And third, content listing advertisement and mislabeling products must be modified immediately. If I might arbitrator, I will now turn to our first submission. In our first submission, we have 2 arguments. First, an injunctive relief is an acceptable remedy for get small. An injunctive relief is an effective tool in preventing illegal trade practices of consent. It prohibits consent from making money from illegal business firm, and it gives back a fairly competitive environment between many enterprises in general and contractors in particular. Our second argument is...
Okay, well, let me just park on that issue for a second. Why, this is just a claim between two private parties. So why does it matter to you whether we issue an injunction to prevent respondents from selling fake products?
I understand the question. We need the judge to prohibit consent from selling the product made from illegal business to protect our customers, because if this protection applies to consent, the customers will have that they were cheated by consent, and that affects our enterprise.
But see, this is it seems like the damage to you though is in the past. You bought the person, suppose you're not going to be buying any more purchase, let's say, providing you with misleading. So, but why the injunction? How do you have, how will they, if we don't get the injunction, how does it harm you? Why does Jack Smalls really need an injunction?
I understand the question. If we don't get an injunction, the customers will suspect all the products in the product market, including our product. They will have no trust on what is on the label and what is advertised on the including our product, and it affects us. It costs us very irreparable harm. So we need an injunction to stop them from selling those.
What did you plan for the damage? What did you plan for the damage?
We pay for the damage.
Actually, they don't get enough amounts of damages.
apply for injunction to be granted?
The arbitrators, I will mention the answer in my next submission regarding the authority in granting
Can you answer it now?
yes. The arbitrators sorry, the Singapore court has the authority in granting an injunction and would enforce such an order issued by an arbitral tribunal. Since the parallel arbitration only provides for interim relief, but the Singapore court has the ability to enforce a permanent injunction issued by the arbitral tribunal.
But whether the arbitral tribunal have the right to grant an injunction, permanent injunction, because you want us to grant an injunction that stop the respondent from continuing selling their products.
We would like interim relief from the arbitral tribunal. Then the permanent injunction being granted by the Singapore court.
Okay, just moving on.
Our first solution is content listing advertisement and listing products must be modified immediately. In our first solution, we have two options. First, listing advertisement is likely to deceive customers. Content advertising products as a high quality overall product, which only has the feel of real product but not made from real product. Since the line between the fake, the high quality paper and the real product is so blurry, most buyers couldn't tell the difference between them. In the act of receiving advertisement on our content and private activities, the general principles in Singapore court of advertising practices. I will follow the next announcement.
I know that the time is over, so give me brief your submission.
I will leave it to brief comment.
Okay.
And companies must label their products correctly, since a supplier knows more about the products than the customers do. So it's their responsibility to label them correctly so the customers can make the right choice. In conclusion, content and fair business practices should be stopped by an injunctive relief. Singapore court has the authority in granting an injunction and would enforce such an order issued by arbitral tribunal. And content misleading advertisement must be modified immediately. That concludes all my submissions here.
Okay. Thank you. So now that's on number 12 to respond on the submission made by the panel.
Good morning, Mrs. Chairman and other arbitrators. My name is Manjung Rupiah. It is my honor to appear in front of Halal Regional Science Bureau Arbitration. Pleading on behalf of Constate Imports, the respondent in this case. With me today is Ms. Moni Yusuf and Ms. John Lin. May please the arbitrators in the next 7 minutes. I will
liability that you have just referred to have been decided, were decided by arbitration or decided by the court? It were decided by the court, right? The case that you have just referred to is were decided by the court. So I just want to ask you whether the president, okay, the judgment will help delivered by the court, dividing on this kind of law.
In my opinion, I think the case will be right because they based on many precedents, not just one. It is accepted in countries which use credit and measure source strategy. May I move on to I place in three factors to decide. First, how much is reasonably foreseeable. Second, the claimant and the respondent must be in a close proximity. And third, it must be fair and just to impose liability.
Well, I think it is reasonably foreseeable why, how their business can be damaged by labeling or their customer base buying fake fur because they don't want animals to be harmed in the process of their product. So when you try to pass off real fur as fake fur, it should be very clear how it may harm businesses that purchase your furs. My question is, how is that not foreseeable? I think anybody can foresee that.
We are formed to say and duty of care.
Yes. And so I'm saying if an element of duty of care is foreseeability, I think that at least that element is met here. So I can respond to that.
You said that it is not foreseeable, right?
No,
Yeah, you said it.
So I'm saying that it seems to me to be foreseeable. It's very foreseeable that you sell fake fur.
We know that whatever kind of fur is synthetic or organic, the interest in consumers
Is that what you're getting at?
What do you mean by that?
because synthetic fur is on the fashion. And people, especially those who actually experience into life. And of course, we are aware of what's in the environment. We just import synthetic fur. And although we know it doesn't work, we satisfy the interest of the consumer. It's the educators, they are well aware of this idea. May I move on to secondly, I want to state that there is no proximity relationship to the planet because there are two separate department stores. The respondent specializes in importing clothing and other products from other countries like India and China, and of course there has been no contracts between the claimant and the respondent. The respondent did not import any garments for the claimant. And last, imposing liability for the respondent is unreasonable because it is beyond the respondent's ability to know all the components of the garments imported. And it is the respondent is also exempted from liability to know the garment's material because it should be the duty of the manufacturers who label it. And
So only the manufacturers will be responsible for the quality of the products, not anyone in the distribution chain will be liable.
I understand your questions, and as an importer, for so many years ago, there is no dispute and it was a business question.
Because I would think you would need to, if you're going to say definitively that your product is co-occur, you need to be able to stand behind that representation. If there's any question about what you're getting from the manufacturer, you need to it seems to me that you would need to indicate that somehow to say, can't guarantee that this is fake or real fur.
Because the time is over, so may I have a few more minutes to consider?
You can have 1 more minute to answer.
Yes, the arbitrators, of course, we did test our products in some way, and there is one efficient way to test it, sample testing, sample random testing, and human society, excuse me, I move on to my second candidate. So it's never.
You could just go continue because that's a concern that we have. So answer.
You do not have to continue your submission. You should only answer the questions that are identified and anticipated.
Because we are imposers, so everything we know, we just follow the exploratory documents, and we trust each other for so many years. About the second argument is about misleading labels, mislabeling the element as just a threat. We submit that the respondent exporting partners who should be responsible for their products, and if there were any signs of mislabeling, the respondent is only a victim being detained as partners. Moreover, the respondent advertising has satisfied 3 conditions listed in the advertising process of the United States. First, it is truthful and objective. We claim that the product can touch the smell and the feel of real fur. There is no difference from the facts, and of course, we know that a good activity of product is needed to be real, and organic product also needs organic products. And also, scientific tests can be a good support for it. And last but not least, the respondent advertisement is not a conduct of unfair business practice that the respondent has planned. Because such advertising does no harm to consumers and also personal rules to the opponent. It is my position, and basically, my question will continue. My name is Morgan Newman, and in the next 7 minutes, I will be responding to the issue of the claimant about the authority of the actual tribunal to resolve this dispute. And mainly the actual tribunal. For this second commission, we have 3 arguments. The first, the actual tribunal has no authority to award a penalty. Second, they also have no authority to impose a permanent injunction. And third, even an interim limit is not feasible in this case. So with your permission, may I move on to my third argument. First of all, the arbitral tribunal has no authority to award a penalty, as the claimant says that they do have this authority, but actually they never indicated what is that penalty means and what is the exact claim for this penalty. So, in our argument, first I will make the penalty punishment imposed by the statute as a consequence of commission for offense. And as a demonstration, we have the Security Act, Exchange Act of 1934, Section 21A, the civil penalty for insider trading. It states that only a court, judge, or public administration can impose a penalty. So there are reasons to support our argument that the arbitral tribunal holds no authority to award this penalty. The first, according to the document that we have, the Article 8 of Further stipulated provision on awards that
law, but court judge or
I just want to interrupt. The claimant did not claim for penalty. They have to claim
I'm not sure that in the last submission of Ms. They say that they want penalty, but they're not retired. They do say, for sure.
The arbitrators, I have to.
I'm sorry, we have time to recap, okay?
But they just make it quick.
Yeah.
They're not deciding to it.
All right.
All right. And mentioned the civil penalty for insider trading that we have only court, judge, or housing administration can impose this penalty, whereas this dispute is managed by a private arbitration. In short, it is impossible to decide on compensation in this case. And with your permission, may I move on to my second argument? Our next argument regarding the authority of the tribunal to raise a permanent injunction on the respondents, and we observe that the tribunal has no authority to do so. And as stated in the black law, permanent injunction is a decision in the final hearing on the merit, which means the final order of the court to make a person or entity refrain from certain activity permanently.
So you refer to black law dictionary, right?
Yes.
Yeah, but whether the black law dictionary is compromised on this kind of driving rule.
We just use the black law dictionary to explain the definition of the permanent injunction.
But I love that you said that it's made by the court. So whether the injunction must be made by the court or whether the injunction can be made by arbitral.
This depends. To our opinion, the permanent injunction is the authority of the court, but the actual tribunal may propose the injunction relief, which means an interim relief. In our next part, I will present it.
All right, but I just want to know right now that what is the authority for that submission, that conclusion that we have just said?
The source is the Security Exchange Act that I have mentioned. It clearly says
Security Exchange Act
Security Exchange Act
and the jurisdiction
or the Supreme of the United States.
the United States. So whether the act of the United States would govern this dispute?
Security Exchange Act, which is international.
This is international?
Yeah.
Why? What is this international? It is the act that issued by the United States believers.
There are many similar regulations to each other. So we
Okay, well, let's assume that we do have authority to issue some sort of injunction, just assuming that we have that power. Let's talk about the substance of this claim. They argue that they need an injunction because consumers will lose faith in the entire market that synthetic fur retailers. There's no injunction put in place. I'm a little sympathetic. I see their point. Consumers may just stop buying synthetic fur real fur if they feel there's purchasing activities by support killing animals. So how do you respond to?
I understand the and they give the status to ask for the injunction. But actually, which we are now doing is the authority of this injunction. We not mention the content, just the authority. Whether this
Okay, so what we're looking for is if we have authority to issue the injunction, should we issue it or should we? If we do have the authority to issue the injunction.
Of course not.
Okay, why?
Because I mentioned about we claim that we don't mislead and mislead or abuse realtor, we claim that we use the synthetic word and we not mislead or specifically attaching before. So nothing is clear out of our arguments inside the conversation. That we have no duty for conversation here and in my period of operation.
Okay, so you have one more minute to sum up your argument.
Okay. After they asked for the interim period, okay, he told me regarding the interim period, as clearly stated in Article 26 that the tribunal has the authority to grant an interim period, but actually it's a limit in circumstances. And if the government asks for the interim period, they must satisfy several requirements in Law 3, 6, 7, and 8 in Article 26 of the Protocol Rules. And as far as the fact that we have the government has yet been assured about these requirements. And last National Court Endangered Species or the CITES provide a right of action between different entities to call for only government can seek and enforce its law and treaties, and furthermore, none of the employees have taken any action to prevent the action from the beginning. So in the end, based on the above-mentioned tradition, we respectfully request the Editorial Tribunal to arbitrate that we have properly performed our important business, and second, our responsibility in disclosing information and efficiently carried out. And last but not least, the Editorial Tribunal cannot prohibit the respondent from selling the government law of endangered species, nor penalize the respondent. The Editorial Tribunal
The response mentioned about let's say the court decision, the dictionary, the other country law like the United States law, and also you mentioned about the colonial rule. Could you elaborate on which applicable law on that your argument is based on? We are binding.
Yes, I understand your concern because we are not possibly requesting you arbitrators to abide by the law of the United States and of the United Kingdom. We just put out the precedent case to persuade and hopefully persuade you to render, take into consideration of our arguments. And that is just the point that we just
to give them the right to say something, okay? So,
we gave her audience, so if we had concern, we would raise it. Okay.
so, okay. So you now have 5 minutes to rebut, right? Remember, the procedures is very important, okay?
Thank you for your admission, arbitrators. I just have one question to raise for the respondent. Do you think that it is proposed in the process of the clause to sell foreign clothing into endangered species animals?
So I think that you just make your rebut, okay? Rebut, okay? Continue to make your rebut. When you answer in the self rebuttal, okay?
This is not a cross-examination. We're getting a
I
rebuttal.
want to say that the respondents have claimed the manufacturers and retailers have legal responsibility and all the duty to care of the commodities. That's their claim. And why? I don't think there's no reason for them to refuse the responsibilities in taking a private investigation, inquiry in the commodities, because they are enterprise, the selling police for the consumers, and that they are bound to protect consumers' welfare. They're bound to protect the consumers' opinion and beliefs. So you can't tell that because they are limited in something, they refuse to conduct their responsibilities. This is the situation. And the next part, they have to.
I think they made the point that they rely on their manufacturer's representations just as much as we rely on their representation. So I think that, based on the argument that you're making, it could also be used against you. They have a responsibility to check, and you also have a responsibility to check.
Yes, they have responsibilities to check all communities. In Singapore, there's no legal rules. Legal rules is a pro-labeling act. But as a source of reference, we can see the United States. They have pro-labeling act, which force the retailers and manufacturers to ensure all the commodities are checked before handing the customer.